thank you, Fordham, for running what's been an absolutely unbelievable tournament. I've enjoyed myself immensely through the past 2 days. Shara for being a great partner. He's dragged me all the way here to semifinals. I'm so grateful for that. And really good friends on side opposite for delivering what I know is going to be very, very intelligent and nuanced off-center cases. So that said, we have a case study that I run on occasion with Shara. It's my favorite case that we share in common. And what we're going to do, Mr. Speaker, is time-space you back to the Supreme Court in 2002, when the court was deciding a case in which a 17-year-old named Roper told his classmates that he was going to rape and kill his teacher. He did this and subsequently threw her body on the bridge. He was tried and convicted at the lower court level and sentenced to death. It got to the Supreme Court, and the United States Supreme Court, on appeal, overturned his conviction on the grounds that, under the 8th Amendment, no state could individually decide to execute anyone under 18 years of age. We're going to argue today that side government says this case was wrongly decided. Just one other thing is that this case, the Roper v. Simmons case, overturned a 1989 decision, Stanford v. Kentucky, that said that minors could be given the death penalty by the states. You guys have any questions?
How old is this?
17.
No.
Cool. So the first thing that Charlotte and I want to talk about, pretty generally speaking, is the idea of the role of the judiciary and what role that the judiciary should play in American politics. We would tell you that the judiciary shouldn't be the sort of moral arbiters of the American population, deciding from their own individual perspectives what is and what is not bad. We would tell you that the judiciary's purview is strictly interpretive. They should be sort of the they should not be the moral expression of society. We would tell you because they're not the branch that's best suited to deal with those particular issues. We think that the moral expressions of society should come out through the legislative process, through individual legislators making the rules. We think that's the more appropriate role in order to suit the balance of power. We would tell you also that there's sort of a presumption against limiting the democratic will of individuals, of limiting the democratic will of the American populace. We would tell you when you place the power in the hands of 9 individuals who are unaccountable, who aren't democratically elected, we think that's a subversion of the popular will and needs to be justified to a very high standard. We would also tell you, and thank you, that there are 2 ways of decision making. And we would tell you the first one is sort of a stare decisis way of decision making, where you sort of defer to past and previous court precedents in order to attain some sort of legal consistency. The idea that people should always sort of know what the laws are. They shouldn't be fluctuating with the policy preferences of justices. And I think there's been a lot of evidence about why justices on the Supreme Court and courts in generally tend to inject their policy preferences into their decision-making process, especially in cases like this. When you look at death penalty cases historically, and you look at sort of Brennan and Marshall, whenever they would rule on a death penalty case, it would always be unconditionally against, because they just individually believed that the death penalty was something that should never ever exist on any grounds. But recognize, Mr. Speaker, that the majority of Americans don't feel that way. And we'll talk about why that's important later. Sure.
But you're saying that morality should play no part in the courts or in the government. But look, we have a government that cares about things like fairness and justice. Are those moral values?
Sure. We say that the court's role is to use the Constitution to interpret decisions that are concordant with the principles of the Constitution, which we think enunciate fairness and justice and principles like that. They shouldn't use their own individual values of fairness and justice. Should those values be inconsistent with what the Constitution says? So let's talk about what the Constitution says. This is going to be my second main point of analysis. We're going to talk about the 8th Amendment, because the court did rule that this was unconstitutional according to cruel and unusual punishment clause of the 8th Amendment. And when you look historically at how the court has sort of interpreted the 8th Amendment, they've used this standard called the evolving standards of decency as the way to evaluate what is and what is not cruel and unusual punishment. I think you need to be very careful in this particular instance when you rule that this is cruel and unusual punishment, overturning a previous court decision, because you as the United States Supreme Court or the Supreme Court can never go back on this decision. Legislation can never be passed to the effect of saying that states can actually do this in the future. So we would tell you that the court is generally speaking retroactive in its dealings. That is, it looks to changes in the legislature in order to justify the fact that the standards of decency in America have actually changed since the founding of the Constitution. Take the case of Lawrence versus Texas, for example. The court ruled in this case that there was an evident evolving standards of decency in order to decriminalize homosexual sodomy, because 22 independent state legislatures had independently ruled to this effect. They could look at these legislatures' decisions and say, look, people, through legislation, through the appropriate avenues, are saying that our standards of decency have changed so much that we can justify a decision that's consistent with the evolving standards of decency, that this is actually cruel and unusual punishment, that anti-sodomy laws are actually violations of due process in that particular case. So the second thing under this point is this cruel and unusual punishment? And there are two ways to look at this. The first one is you look at the framers' intent, right? Was this cruel and unusual at the time of the founding of the Constitution? And we would say, pretty obviously, no. You had a lot more responsibilities than you do now during the founding of the Constitution. They had a lot more severe punishments for things at the time of the founding of the Constitution. When you were young, when you were 17, you had 14 farms, no thank you, and 3 kids, and you had a lot more responsibility than you had now. So the question is, have our standards of decency evolved from the founding of the Constitution to now in order to merit this change? And we would tell you absolutely not. The reason why this is the case is that 38 states have legislation expressly permitting their states to execute those individuals under 18 years old. So what we will tell you is that there is no grounds for the Supreme Court to rule in this particular case that American standards of decency have changed. The third thing we want to talk about is the idea of bright lines. And we think that you don't set the bar. We would tell you, first of all, that bright lines are a proxy for actual individuation. We use bright lines in particular cases, not because we like them, but because they're politically expedient. We don't think that you should set the bar at 18 because that's the best age that people, look at examples like John Baker. Clearly, there are people who are cognitively capable of doing such heinous things. We will tell you that we use bright lines because they're politically expedient. For example, we set the voting age at 18 because we think it's absolutely impracticable to send out a referendum to every individual member of society to determine whether they're capable of doing things like that. That's an example of using it as a political expedient. But do we need to use bright lines in this case? Do we need to set the age at 18? And I don't think so. I think there are appropriate ways to gauge whether an individual is capable of committing crimes worthy of the death penalty, even if they're not 18 years old. First of all, there's always prosecutorial discretion. Individual prosecutors have the right to decide whether they want to try this individual as an adult. There's the introduction of mitigating and aggravating circumstances in each individual criminal case and criminal trial. Then there's the guilty or innocence verdict. Guilty has to be decided in 48 out of 50 states by a unanimous jury. There's the sentencing phase, and of course there's a number of level of appeals process that these individuals can go through. So if all of these checks are met, we don't think we need to use a bright line. We think the trial process serves as an adequate way to check against abuses of the death penalty to people who don't deserve it. The final thing we want to talk about is the difference between minors and non-minors. And I think it's just legally inconsistent to say that these people, whereas in other spheres we've given them rights, are incapable of doing these things. We say that minors can become financially emancipated at the age of 16 and operate as autonomous individuals in financial and responsible control of their lives, but they can't do things like engineer a murder and throw their teacher off a bridge. Finally, I want to close on the idea of victims. And I think for victims, the severity of a crime is not decreased just because it was a minor committing the crime. Moreover, we would tell you that localities are best suited to decide this. They're most connected to both parties, and they're going to have the most incentive to try to create justice for each party insofar as whatever crime it is affects the people within their region specifically. Finally, we think there are just going to be fewer victims. There are not going to be any more 17-year-olds in 364 days who think they're going to get away with it just because they're not 18 yet. And we're also going to tell you that this is going to limit gangs and recruitment. They're no longer going to have an incentive to recruit people under 18 just because those individuals can get away with crimes that they normally could. So for all of these reasons, we're very proud to propose.
Hear, hear. I thank the Prime Minister for his remarks and announce on the Leader of the Opposition, Adam Rose, to deliver the second constructive speech of this round, not to exceed 8 minutes in length. Hear, hear. Hear.
Okay, well, of course, thanks to everyone here at Fordham for an excellent tournament. Of course, thanks to SideGov for an interesting case. Now, the first thing I want to talk about is whether this punishment is cruel, right? Because I think they pretty well acknowledge that if it's cruel, it's, banned by the Constitution. So I think at some level, we have to just look at intuition, right? I think cruel is fundamentally a standard that has something to do with societal norms and with moral beliefs, right? But I think that the vast majority of people in our society inherently see this as a cruel thing to do. See this really in a sense as inhumane, right? Look, we think that children are different than adults. Yes, exactly where the line goes is a little tricky. I'll get back to that later. But there is a real difference, right? What I want to know from them is, would they have any barrier in this, right? Would they actually say that like 4-year-olds are okay to execute? Like, where do they want to draw the line, right? I think they have to explain how they're going to deal with the obvious cases. Children don't actually have the same kind of responsibility for what they do. They say, like, at 16 you can handle your finances, right? But look, we try you as a minor, right, in general, in court. We don't think you have the same responsibility for your actions. We think that in general, you don't get the same kind of treatment that adults do, and that you don't face the same kind of punishment. We recognize a fundamental principle that the rest of society is there to care for children, right? That they are owed something by society. And even if they did make the decision to do something, that decision is not just a failure of theirs, but a failure of society at large, which is responsible for raising them and responsible for treating them as, in a way that would result in their acting morally, right? Given that what children do is largely a consequence of what the adults of society around them do, that we do believe it's some responsibility to raise children well, then up to some limit, we do think that children need to be treated differently, that they're not as responsible for their actions. The next thing I want to talk about, surprise, surprise, is whether this is an unusual punishment, right? Look, I think it's pretty clear it's unusual, right? Many states don't have it. The states that do basically don't use it, right? It's next to unheard of for someone below the age of 18 to be executed. Internationally, it basically doesn't exist. The only countries that have it are countries that we see as just horribly inhumane and unjust. This means two things. First of all, it means that our society sees this as bad, because the fact that they have it is one of the reasons that people see these governments as unjust and as inhumane. So it says something about how people within our society feel, but it also just clearly means that the punishment is unusual. Sure.
If it's so dramatically unusual, isn't that kind of a check to make sure it's not capriciously and arbitrarily applied to, say, 4-year-olds?
No. The fact that something's unusual doesn't mean it's being applied intelligently. It means that whether you get it is a matter of which prosecutor or which judge you happen to have, and all sorts of other random factors, right? It doesn't mean it's being applied well. I don't think that makes any sense. Finally, though, I want to talk about intent, because I think what they will recognize on this is that no crime that's deserving of the death penalty doesn't involve a proof of clear intent, right? That this is actually fundamentally important to the situation. Now, this is true of first-degree murder, which is like the reason why most people get the death. Now, I don't think that children are capable of having the same kind of intent that adults do, right? Intent doesn't just mean knowing that someone will die as a result of what you do, right? It means really being morally responsible for that outcome, which means understanding, right? Not just that it's bad, not knowing intellectually that it's bad, but having the life experience that makes you really understand exactly how horrible something like this can be. So I don't think it makes sense then to say that children have the same kind of understanding of what they're doing, the same kind of understanding of their consequences. It's just clearly more forgivable when children do things than when adults do. We know this is true within society. We respond differently when children insult us or do something else dumb than we do when adults do the same thing. We recognize that more things are forgivable or more forgivable than they would be for adults to do them. So I think society as a whole does recognize this. So let's go back to the case. They talk about the role of the judiciary. And they say, well, they're not meant to be moral arbiters, right? Except here's the thing. The standard that applies here is cruel and unusual. Cruel and unusual is fundamentally a standard that expects some sort of morality to come into play, right? Now, what they should be deciding clearly should be a function of what's in the Constitution, but the Founding Fathers did believe that some base moral standard was up to the court. They did expect the court to overturn these things. They say, well, the Democratic legislature should decide this. But look, there's a reason we have a cruel and unusual punishment check, or for that matter, any other check within our Constitution, right? Is that we believe these are things that aren't up to the democratic process. That even if most people thought they were true, right, thought that this was a good law, it wouldn't be acceptable. That's the only reason we have any any limits in legislation in our Constitution, and those arguments still obviously apply here. They worry about stare decisis, right? Except here's the thing, they've given us perfect responses to this in their case. They say, first of all, that the standard is evolving moral decency, right? Which is something that fundamentally changes over time. It's not that the Supreme Court is actually reversing its interpretation of constitutional language. Their standard is still the same. Their standard just relies on something that changes with context. And as context changes, therefore the application of the standard also has to change. This won't come as a surprise to anyone. But beyond that, we don't think stare decisis is nearly as absolute as they say. Right? There's a substantial period of time there between the previous ruling and this one. Obviously, you change things. We got rid of the death penalty completely and brought it back. Right? We do things that undermine stare decisis all the time. We weigh stare decisis against how important the decision is. Right? When there's a decision that's clearly important, when there's clear legal basis, and you're not actually changing the fundamental interpretation of the Constitution, stare decisis doesn't hold the kind of weight that it might in other circumstances. Next, though, they talk about the Eighth Amendment. They say it depends on these evolving standards of decency. I don't really understand why this is a point for their side. They say that the decision cannot be reversed. I have absolutely no idea why this is true, right? What happened is they reversed a previous decision, right? Obviously, these decisions can be reversed. The death penalty ruling was reversed, for example, right? That's a pretty good precedent, right? If eliminating the death penalty entirely can be reversed, then I don't see why some interpretation of exactly where it applies can't be reversed, right? They say, well, you look to the legislature for these standards, right? And they cite Lawrence. But you don't only look to legislatures, right? You look to legislatures as one example. Recognize that many of these laws were passed a long time ago, aren't really being used now, and are just still technically on the books. These aren't necessarily good evidence, this isn't necessarily good evidence for what is a current moral standard, what's actually good in the situation, right? You use what's law in most states, true, but you also use how society sees things, how the public sees them, what the public reaction is to when this happens, right? The fact that there is such public outcry, for example, no thanks, is good reason to believe it's abhorred by a large number of people. You look at how the public responds to other countries that do it, that kind of thing. It's very clear, I think, that the public, in large part, sees this as immoral. Then they say, well, cruel and unusual. They say the standards haven't been. I think I've dealt with that. Then they talk about bright lines, right? And recognize here that they're just completely undermining what they say about the role of the judiciary, right? Because none of these arguments apply if you don't think the judiciary should be trying to make decisions that make for good policy. If you think, as they seem to, that you should only be basing things on exactly what the Constitution says, and on exactly what was intended by the Founding Fathers, then whether they would make bad policy is irrelevant, right? That's not what they're claiming is the basis for making constitutional rulings in the first place. So none of these arguments apply by their very own standard. But then they say, we use these as a proxy for individual decisions, right? But we can't make this decision in every circumstance. They talk about prosecutorial discretion, they talk about mitigating circumstances, things like that. And yes, we do consider things like that on an individual circumstance. But there's something to be said for the fact that you are young, that you haven't had this kind of experience, right? That argument isn't going to change on a case-by-case basis. That argument's going to be the same every time. And it seems like we should have a consistent justice system that treats the argument differently, but it doesn't treat the argument differently every time it's made. But besides that, those checks are imperfect. They cause a lot of cost to the system. They cause a lot of harm. Even if you do end up winning on appeal or something, you spend a lot of time being punished, right? You've gone through a lot of cost, even if you don't deserve whatever punishment occurs. And the fact is, they're not perfect, and they make mistakes all the time. And if we know that something is almost always true, then I think we should err on the side of not executing people who don't deserve to be executed. Recognize that execution is irreversible. And therefore, I think deserves a particular amount of care when dealing with. You should have a very high standard for executing someone, because you can never fix it. Right? They say, yes, victims are just as hurt. Right? True. But we recognize mitigating circumstances all the time that have nothing to do with how much the victims are hurt. It's not just a matter of what's good policy. You don't get to punish people just because you like the outcome. If they don't deserve the punishment you're giving them, it's wrong to give them that punishment. If the punishment violates the Constitution, it's wrong to give them the punishment, and that alone is enough reason not to do it, to give it. We don't have to deal with every practical concern they might have. We're very grateful.
I think I leader of the opposition first, Carson, and now.
There ought to be no bottles in this room. It's really disrespectful to have anything in shattering bottles. Please.
I thank the leader of the opposition for his remarks, and now call on the member of the government, Sharabachi, to deliver the third constructive speech of the round, not to exceed 8 minutes in length.
Thank you, Mr. Speaker, Fordham for a great tournament, Tor for being fantastic, and Side Off for an interesting talk. I'm going to go straight into their points of analysis, and the first thing they try to do is establish some rubric by which we can gauge whether an action is cruel or not. And what is this rubric that they suggest? The rubric that they suggest, the strong standard that they suggest on their side of the house, the infallible line that they suggest is intuition. There's a couple of problems with this notion of intuition regarding decisions made in our tradition. Perhaps they did get it right, that intuition does have something to do with an appropriate moral standard. That's not the question presented in this round. Is intuition an appropriate rubric as a judicial standard? Is what you have to actually talk about, and that's how you actually determine whether a case is correctly adjudicated. What we would ask on our side of the house is intuition simply isn't that rubric. What we would tell you is a lot of times this exact intuition is what allows many judges and many justices to inject their own type of policy because they feel that that policy is intuitively moral, is intuitively giving them a good visceral or a good reaction from having it implemented, not right now. What we would tell you is that a lot of the abuses we talk about judges injecting their own ideas about policies into the court decision, become even more salient when you use the idea of intuition, because intuition is something that simply can't be checked. How do you check this intuition? You can't go to the state legislatures because, hey, their intuition doesn't matter, it's my intuition that matters. I think the type of standard you should use is a standard that has a verification mechanism. And what is that standard? That standard is explicated in the evolving standards of decency, whereby you realize whether the standards have changed from the last court case that actually happened. The way you gauge this is not by some moral language that a judge uses, but the way you gauge this is by saying, have state legislatures evolved in a direction to illustrate that the community or the public is moving away from this kind of punishment? The answer is a resounding no, Mr. Speaker, and at that point you realize that the moral intuition isn't as salient as the sort of rubric that we evaluate and that we use in our Constitution is whether the states have evolved this way, whether there is a public sentiment. Understand you might come up here and talk about a public general intuition, but there's no way for us to gauge that than by the actual policy-making processes that exist. And within those policy-making processes, we use the votes cast by senators that represent the intuitions of the individuals. So if they even want to talk about intuitions, we get that, and the intuition is to have this kind of punishment. The second thing they talk about is this whole idea of children are different, and children are going to be different. As a result, they shouldn't be responsible, and where are you going to draw the barrier? Are you going to kill 4-year-old kids? What we would tell you is that the reason a trial process is very important is because you don't have to rely on general notions or general intuitions of rationality. Instead, for example, in a trial process, you can have a psychological expert come in and determine whether an individual had the faculties to commit a crime and whether he is a 15-year-old that's very stupid or a 15-year-old acting with the rational capacities that an 18, 20, or 30-year-old person would act with. I think that's a great natural check against convicting a 4-year-old because perhaps on their side of the house, there is a mutant 4-year-old. A mutant 4-year-old with a brain that is just absolutely out of control. He is engineering murders. He's killing babies. Other 4-year-olds that stole his toys. Something like that, Mr. Speaker. And in that case, I suppose if you want to evaluate that rationality, you shouldn't have the bright line because gosh darn it, we should get that mutant 4-year-old. And the way you get it is by having some sort of judicial standard. The next thing they talk about is the whole idea of that, simply because children can live by themselves doesn't mean they have it. I don't think it's an unreasonable standard to use that if we think that children can, or that 16 and 17-year-olds can manage their own finances, live by themselves, and perform all of these kind of secondary tier things, I think the basic moral rubric of these individuals should probably be intact by then. Because if we feel that they're able to exercise these sort of secondary kind of rights that aren't fundamental rights, then at that point you realize they're certainly probably moral enough to know the difference, the very basic difference that's taught at a very early age between right and wrong. I think that this emancipation point really gets to that. The second thing they try to talk about is this unusual? And the sort of answer they give to this is yes, it's unusual because it's rarely done. And because it's rarely done, it becomes absolutely unusual. No, Mr. Speaker. That's not the kind of standard we use to determine whether something is cruel and unusual. Rather, the standard we use to determine is whether when the Constitution was created, our framers would view this as something that is absolutely outside of the norm. You can couch it in that kind of context, and I'll get one of you in just a second. What we would tell you is that if you look at when the Constitution was created, this clearly isn't true, because more severe, more like visceral, punishments against visceral reactions existed. But then we look at whether it's cool, whether it's unusual now. And I think it's not unusual at the point that 38 states actually allow it to happen. That doesn't make it unusual. The fact that it's seldom used doesn't mean it's incorrectly applied. That means that the checks are actually working, and that we seldom decide to kill individuals is a good thing. They have to illustrate why that option ought not at all be available. One or two.
The fact that it seldom exists doesn't prove that it's being incorrectly applied on its own, but it does definitionally prove that it's unusual.
Okay, there's several problems with that analysis. Like the standard we use isn't that it's punishment unusual, but it has to be cruel and unusual. I think that you can't sort of take one part of that and evaluate it on its own. But what we would tell you on our side of the house is that the cruelty standard becomes much more salient in that regard. And the unusualness, like simply because we have a society that has punishment X, but doesn't use punishment X, doesn't make punishment X unjustified. It simply means that there are checks and we don't do certain severe things. I think as a society, simply because we don't progress to the same extreme form of punishment, doesn't mean that the punishment is unjustified. It just means that we think very, very hard before applying that kind of clarity. And I think that's very, very important on our side of the house. The next thing they talk about is this notion of intent, right? Because what they tell you is that children don't have intent, and children don't have as salient of an intent as adults do. And as a result, they shouldn't be held completely responsible. The first response I would give to this is you can sort of gauge this kind of intent by analyzing the fact pattern. Now, where do you get an analysis of the fact pattern? You get that fact pattern analysis on our side of the house. Understand if you have a situation where the fact pattern dictates that this was an individual who planned this out very meticulously, who did this and then bragged to his friends that he'd never get caught. I think that describes a very salient intent, Mr. Speaker. And on our side of the house, psychological testimony and testimony by these individuals can actually elucidate the intent. I don't think somebody who's 16 or 17 years old has mitigated intent. And if they do have mitigated intent, we don't rely on a bright line on our side of the house. We actually allow for a trial process that gleans the level of intent they have. Understand, if a trial process can glean intent for an adult, certainly a trial process can glean intent for a child, especially somebody who's 16 or 17 years old. Not really. Let's go back case side, because a lot of Tor's points go kind of under addressed. And the first thing Tor talks about is the role of the judiciary, and how the judiciary isn't the moral arbiter, and there's an abuse of democratic will. There's a presumption against a democracy that 9 individuals should not be allowed to do this, and there's 2 ways of making decisions, and the sort of stare decisis principle. The first thing we get is that there's fundamentally a morality in our judicial interpretations, and as a result, morality is salient. Tor's first point wasn't that our constitutions and our laws are completely devoid of morality, but instead what it was that morality, or those notions of fairness, are written within the Constitution. And when those notions change, what we do is not inject our own perceptions of how they change, but actually look at things like voting patterns in the state legislature to see whether the sort of moral aspects or the moral outlooks of the country have changed. It's not a fundamental moral obligation. It's an obligation we allow to the states, realizing that sentencing is something that's not determined in the Constitution. Right? The Constitution that doesn't say everybody must sentence X, Y, and Z, and always must have this type of sentencing. At the point that we leave it to the states, it's not this fundamental inalienable right, because we allow the states some autonomy in this regard. At that point, you realize that if there is that autonomy, it's not this kind of fundamental right that they talk about. Also what they talk about is the whole idea of, that the context changes, right? And because the context changes, you can't look at it in this kind of way. We would see if the context changed, again, look at the state legislatures, at the point that they haven't had this kind of legislation, the context perhaps has changed in the minds of the judges or in the minds of MITA, but the context hasn't changed in the minds of the American people. And I don't think you should have that moral injection into policy. Tor also talks about the Eighth Amendment, the evolving standards of decency. It's not cruel and unusual in terms of framers' intent. It's not cruel and unusual in terms of the evolution. And the Supreme Court can't sort of usurp this power. The response we get is it's not the current moral standard, but there's a visceral public reaction against it. Again, what I would tell you is the fact that there's a visceral public reaction against it doesn't necessarily mean that the majority of individuals feel it's an unjustified kind of punishment. Rather, it means that the individuals who are most likely to express themselves, individuals perhaps in civil rights groups and things like that, are expressing their opinions, and as a result, those are the opinions that are being reported to individuals. I don't think that's at all a rubric. I think when you make these decisions, you don't say, what's the cruel and unusual spectrum on CNN this morning? What you actually look to is the government policies that exist, and they don't get that on their side of the house. The next thing Tor talks about is bright lines as a proxy for individuation. And Adam simply gives us the glib response that you can't use it in every circumstance. Why? When the death penalty is being applied, there's obviously going to be a trial. There's obviously going to be a sentencing phase. On our side of the house, you can use it in every single circumstance. And that's exactly why we win this round. Because on our side of the house, there will not be one single unjustly punished individual, because each individual that is potentially going to be put to death will be somebody that actually goes through the trial process. On their side of the house, I guess the response they can make is, well, the trial process can be wrong. I really want them to do that in MO, because I think at that point they realize that they've kind of shot themselves in the foot when we rely on the trial process for sentencing and criminal justice and things like that. We also talk about how prosecutorial discretion exists. There are many checks, no response. Finally, we talk about minors and non-minors. This point doesn't really get much of a response. What we tell you is this whole idea they can be financially emancipated and they know the moral codes. What we also tell you is that there's localities are better suited to make laws that pertain to their own area. For example, Hawaii probably has a greater necessity to deter server theft than, say, Oklahoma. At that point, you realize that Hawaii can create policies that have that kind of deterrent effect much more than other states. So this is a reason why we have it, why we allow for state autonomy, because each community in each state has the ability to tailor punishments to what kind of result is most appropriate for them. And finally, we talk about less teenagers being in gangs. We don't really get a response. I think this is a good thing, because there's an incentive to not use these kids because they'll be punished as harshly if they're deemed to be smart enough and deemed to be, vitriolic enough. We're very proud of this.
And Adam for a great speech, totally fine. Now, the first thing that Adam talks to you about is this standard of cruel and unusual punishment. The actual standard which is in fact laid out in the Constitution, which side government thinks we should be particularly relying on, right? I mean, the arguments which they premise their case on is that, we shouldn't be looking to morality and judgments like that. We should look at what's in the Constitution. And what Adam and I are doing on Side Up is taking the exact words in the Constitution and trying to figure out what they mean. So, just a bit of perspective. So the first word that we take is the word cruel. Is it cruel? Now, side government has a problem with the idea that we use intuition, right? Like, we said the word intuition. I'm sorry about that. It seems like, perhaps a bad judicial standard to side government because it's subjective and things like that. But if having intuition, if having our understanding of social morality is a bad standard, then perhaps we should amend the Constitution, right? Perhaps we should take the word cruel out of this amendment. Because in order to understand what is cruel, in order to make that determination in the Supreme Court, we need to think about morality in some way. We need the judges to be considering what the public opinion is on what exactly constitutes cruelty. Right? I'm sorry that this amounts to using intuition. Right? I guess that's unfortunate if you buy the standards that have been laid out here. But certainly, if you believe, as I think both sides of this House do, that you need to rely on what the Constitution says in order to make this determination, then certainly you need to appeal to intuition because it's our only way to make this determination. I'd also point out that we're not using the judge's personal intuition, but what they personally like or dislike, as government seems to think, right? We're talking about general societal intuition. We're talking about norms and things like that. Now, the sort of preemptive response that we hear about this is like, no, we don't want to look at this, we just want to look at things like legislatures and stuff like that. Realize that there are lots of ways which we should be gauging societal intuition. Look at things like, what things are deemed appropriate to protest about, right? What do people feel is that outrageous? Look at the sort of general public sentiment with regards to different foreign countries, right? Like, look at the practices in foreign countries and how Americans tend to feel about those countries. There are a lot of ways in which we can understand and gauge what that societal intuition actually is. So then, what we hear is that we should have the legislatures decide, which I think is an incredibly problematic point for the government, right? What is the Supreme Court there to do? Why are they considering what the Constitution says? It's in order to figure out whether what the legislature has said is constitutional, right? So if their judge of what's constitutional is what the legislatures already did, they're never able to overturn anything, right? Because definitionally, everything that the legislatures did is perfect, right? This is absurd. Yeah.
Okay, but they can't just say, this is unconstitutional because I don't like it. They have to actually justify their decisions to the public on precedential or constitutional grounds. So what is the standard that you support on your side of the House for these justices to actually justify it?
Right, well, it's everything I've been talking about for the past 3 minutes. Like, I think that's right? Okay, then they say we should make this decision on a case-by-case decision. What I think this means, first of all, is that if you have if you're poor and you can't afford a good defense attorney who in your particular case can argue why you personally did not have the capability to make that decision, then you're always going to be held responsible for all of your actions, even if you're 7 years old, right? Like the 7-year-old that found their parents' gun, right? Happens to be poor, whatever. I think this is pretty problematic. Right? They talk about mutant 4-year-olds, blah, blah, blah. That's fine. I mean, we'd prefer to design the Supreme Court for human beings. But look, okay, the second thing that I'm talking about is unusual, right? Because the standard is both cruel and unusual. So we hear 2 standards from Shar. He says, well, first thing you have to do to tell whether something's unusual is to look at what was the case 225 years ago, which I think is pretty absurd, just sort of on face, right? That doesn't matter as far as unusualness today, and I'm not really sure why people spend time talking about it. But then he says now, look, 28 states allowed. I'm not even sure that, he says 28, then he says 38. The number changed 5 times. I don't think that they necessarily know. I'm not even sure that number of states use the death penalty. So I think while old laws may be on the books that sort of make this thing technically legal, I think the clear status quo is that this sort of thing isn't used that frequently today. And I think actually it's very interesting. Side government themselves is okay with this. They think that it's good that in the court system today, in all of these cases where states have these laws on their books, that what's happening is this punishment isn't being used, right? If they think that that's the correct decision to come to in a case-by-case thing, then why don't we formalize it, make it the actual policy, right? Because what's important to realize is that the justice system is imperfect, right? The correct outcome isn't necessarily going to happen just because, it's been happening most of the time in the past. If you think that justice and morality and fairness require something to be the case by constitutional standards, then for goodness sakes, we should formalize it and make it actually true for sure in the future. Right? The third thing that Adam talks about is intent. Right? And Charlotte's understanding of this is look, if someone planned it out, then clearly they have intent, which isn't the point that Adam is making. He said, look, you might have planned to take a particular action, but that's not really all that we mean when we say intent. When we talk about an adult having intent to commit a crime, we mean that they understand the full ramifications of all their actions, and really what that means. So they understand the consequences, and if you have a real desire for the outcome, a real intent to create that outcome, it entails that sort of life experience, that understanding of what exactly is going to happen to these people as a result of your actions. We see that children have not developed that kind of understanding yet, right? The sort of real moral responsibility. And we say that adults basically have this moral responsibility for children, are still in the process of teaching them that moral responsibility. So I think when they just sort of claim juries can tell, juries will figure it out. I think what's likely to happen is that juries will be as misguided about what intent means as side government is here, right? They're going to say that intent just means, planning out a particular action. It's a lot more than just planning out a particular action. It's having this complete understanding, which we say children just don't have. Excuse me. So going back to a second, the first thing they talk about is the role of the judiciary. Now, it's interesting because Torr spends a lot of time explicitly saying that judges should not worry about morality, and then Shar tells us, no, it's okay if they worry about morality. So good, I'm glad we got that straight. Right? Now, he says, well, look, we should have our notions of fairness all written down, and we should take them all out of the Constitution when we make decisions about them. But look, what's in the Constitution? The word cruel. Okay? That's what we know from the Constitution. Now we have to figure out what cruel means, so we're going to have to think about it. Right? We're going to have we're going to have to figure out what society tells us about cruel, right? The Constitution explicitly doesn't state what cruel means, so that it can evolve with time, so that we can think about reality and make our decision based on, what that actually is. Like, they seem to be okay with the Eighth Amendment. Excuse me, it's all this chalk. So I think that ultimately, if we're looking at what's written, what we have to do is make this moral consideration. Again, they tell us we should look at legislatures in order to figure out what the evolving moral decency is. I think I've already shown you why this is a terrible idea if you want the judges to have any kind of check on the legislature whatsoever. But also realize that voters aren't voting for the legislature based on this, because this kind of thing comes up so rarely, right? This punishment just isn't used. It's not a voting issue, which means that you don't gauge public opinion based on what the legislatures are doing, because the public simply isn't thinking about it. Right? Then they talk about the Eighth Amendment. Right? Well, we hear this thing about only civil rights groups will be making their opinions heard. We shouldn't just look to CNN, which is great and everything. Realize that their alternative is to look at what the legislature is doing, right? Perhaps we shouldn't just turn on CNN. Perhaps we should do a little bit more research than that, right? Like, I think we can look at the population as a whole. We can look at protests. We can look at all kinds of things that are written in all sorts of parts of society. Like, I think clearly a better standard isn't just looking at the legislature, it's looking at the population in general. Not this. Right? Then we talk about the Eighth Amendment. Sure, Trump doesn't really deal with this because by the time he gets to this point, he's already at 10 minutes and 15 seconds. Well, what Adam says on this is like, look, you don't want to look solely to legislatures. He deals, I think, extremely effectively with the bizarre point that Tor makes that you can't ever reverse a Supreme Court decision. Right? Like, I think when a standard is based on the evolving standards of society, it's really important that you're able to reverse decisions, and very obvious that that's possible. Okay. The next point that we talk about is bright lines. Right? They say you can't have any kind of bright line. You should do everything on a case-by-case decision. They say the trial process will solve it. Right? I think this is silly, especially at the point at which they think that the right outcome in the trials, is always to make the case-by-case decision that children shouldn't be given this. Right? They tell you that that's good that it's so rarely applied. Right? And we think that it should be, we think that if in an imperfect justice system, what we should do is make it some actually permanent decision. Adam points out something very important, right? That execution is irreversible. That if we think there's a correct decision about what should be done using execution, we should formalize it so that we don't ever make this mistake accidentally. I think that's really important to remember. Right? They close on victory. They say, look, the severity of the crime is the same no matter who the perpetrator, but we say we make our standards based on more than this. That we don't just consider the victims, we consider the actual ability and the actual state of the person who committed the crime. That, and we don't hear a response from this. I think we have a more realistic standard for how to enforce justice. While it might be great that they get lower recruitment in gangs, we simply don't think that it's the place of the judicial system to be deciding good policy. We want them to actually be looking at what's in the Constitution. We're the ones that actually give you a standard that involves the Constitution, and we're very proud of this.
Members of the opposition, Roxanne and Mallory call the leader of the opposition at the vote to deliver the first rebuttal speech of this round out to the C4 participant, reminding you that while enthusiasm and welcome, new arguments are not. Here to
Well, thanks, of course, to everyone in the round. And to Fordham, everyone. I think it's been an excellent round. Now, I want to talk about, first, the cruel and unusual punishment standard. I really think this is what the round comes down to. So, let's talk about cruel. We say people think it's cruel, right? Like, this is true of society as a whole. The intuitions of people in general, not just of the judge, tell them that it's cruel to execute children. We say there's a public response to it that's very clear, both in response to our government on the occasions that they do it, and in response to other governments that have this action, right? That you can clearly see this, and that the public in general treats children very differently and recognizes a real difference in what morality should apply to children versus what should apply to their parents, right? What they don't deal with is this idea that what the public sees is that parents are responsible for making their children act in a reasonable way, right? That it's up to parents to raise their children well, and that if children do bad things, that's partly a consequence of the parents' bad raising of their children. This is something that's recognized by society as a whole, and society as a result doesn't hold children as culpable for their actions as they hold adults. Recognize that the death penalty is an extreme thing. It's the most extreme thing in our society. So if you think that we don't hold children to the same standard as adults, that we hold them to a lesser standard, then they don't deserve the most extreme punishment we have. Now, we also say it's unusual. We say there are some old laws on the books, a questionable number, right, that are barely ever used and that doesn't exist anywhere else in the country where we believe there's a just government, anywhere else in the world, right? These things just show that it's unusual. Their response to these arguments is things like, well, just because it's unusual doesn't mean it's unfair or unjust, or that that it's not being applied well. But that's not what we're claiming with these arguments. What we're claiming is that it's unusual, and that's definitionally true. So it's clear that it actually meets the burden, right? It is cruel, it is unusual, which means it's banned by the Constitution. I think that's pretty clear, and I think at that point, the round is over and we've won. But there are some other arguments being made, so I want to talk about those briefly too. They say this will have bad practical consequences, right? That we should deal with it on an individual basis. That it's bad when courts have subjective standards, right? That allow for morality to come into play. But these are all arguments for changing the standard, for amending the Constitution, not arguments for how we should interpret the Constitution as it exists today. Look, cruel is a subjective term. It does depend on intuition. It does depend on what we believe is cruel to people. Yes, and yes, that changes over time. It's a little tricky to judge, but that's the standard. It's in the Constitution. The Founding Fathers didn't have an intention about every decision or every outcome. They had an intention about the standard that judges should be using. And what they said is they should use this standard. Whether things meet that particular standard is a decision that judges should make. And as a result, they should be considering whatever it is that comes into play. Maybe it's a bad standard, but that's not the issue in the round. Now, they say we can determine this on a case-by-case basis, right? In addition to this being an argument for changing the Constitution, rather than for why it doesn't meet the standard, it's also just untrue, right? We tell you, first of all, that these arguments about experience, right, about how you really feel about the outcome, whether you can really appreciate the harm that's done to its fullest extent, don't vary by the individual, right? That they aren't judged by the kinds of planning things that they talk about. So it's not true that the arguments vary. If they don't vary, why do we make every person argue them again for their own sake? What we tell you is that that just makes people with bad lawyers get punished more when they're making the same arguments. That's not how our justice system should be functioning. Look, we have a clear standard. Maybe they don't like it, but it's clear. And everyone agrees that when you hear about a 17-year-old being executed, you find that to be cruel. It bothers you. And I think that's enough to show it's cruel. It's obviously unusual, right? That's just factually true. And what that means is that we should have it still be banned by the Constitution, because that's the standard that we have. We're proud of it.
I thank the leader of the opposition for his remarks, and now recall the Prime Minister to the bill to deliver the final pronunciation round, announced to see 5 minutes in length, reminding him that all local caveats apply. Hear, hear.
Thanks, everyone. I think it's been an interesting round. I have 3 points of justification. The first thing that I want to talk about is the difference between a 4-year-old, 14-year-old, and a 74-year-old. Because I don't want to let them pigeonhole us at the end of the round into saying that there are differences in the maturity and the responsibility levels of these 3 individuals in question. Certainly we acknowledge that on our side of the house. But I would ask you, and I don't think there's been effective argumentation to this effect, is there a threshold for a consciousness of criminal activity at the age of 18? And I think unconditionally the answer to this question has been no. So in light of that, what is the best way to gauge where an individual is cognizant of his ability to commit crime and be punished by the laws of his or her particular state? Is the best way, as they defend on their side of the house, setting the bar at 18 years old? The reason that we use bright lines, we told you in PMC, Charles told you again in MG, makes this justification suspect. We use them because they're politically expedient. We use them in cases like voting because it would be impossible to determine whether each individual voter actually has the capacity to make an informed decision. So we just set the bright line at 18. But is this case any different from voting? And we've told you it is. We told you that the trial process is a very adequate and very sufficient determination of whether individuals are actually capable of doing these things. There are a bunch of checks that we've mentioned throughout the entire round that allow for justice that's tailored to the individual people who are convicted of committing crimes in these particular cases. The only real response that we've gotten on this side of the House is that our position is just going to lead to a mass execution of 4-year-olds. So is this going to happen? Well, first of all, if you buy their intuition argument that most people feel like executing minors because they're kind of immature and irresponsible is viscerally a bad thing, then I think you're not going to have this wave of convictions, of wave of executions of 4-year-olds and 5-year-olds and people like that. Because jurors are going to say, it's against my moral intuition to execute these individuals. But more importantly, there are some cases in which individuals tread the line between being responsible and not being responsible, even if they're under the age of 18. We would tell you the best way to determine whether these individuals were capable of doing it is have a part of the trial process, like an expert witness come, conduct a psychological evaluation, and say that this person actually was psychologically capable of committing the crime, even though he wasn't 18 years of age. If the 4-year-old in the courtroom is sitting next to his defense attorney and making motions to the jurors like this, then maybe he should be executed because there is clear evidence that he's actually psychologically capable of doing this. We don't think that situation would ever happen, but you get the idea. 17-year-olds can do this, 16-year-olds can do this, and we think our justice system protects against the abuses that they come through. So the second thing that we want to talk about is evolving standards of decency, right? Because the framers said that kids can die. That was how this cruel and unusual punishment was understood at the time of the framers. But the court said in response to this, maybe the original intent of the framers was too restrictive. So they built in this exception. They built in the exception that says, in order to determine that something is cruel and unusual punishment, that wasn't cruel and unusual punishment at the time of the framing of the Constitution, you have to show that there is an evolving standard of decency. So how do we prove that on our side of the house? We think the best way, we think the precedential way, is to show that there has been legislative action taken in this particular venue, right? We would tell you that when 38 states explicitly allow for the execution of minors, there hasn't been this public consciousness that they talk about that leads to this legislative action, like it was in Lawrence v. Texas. But more importantly, maybe it isn't legislative action that's the best way of determining it. But on their side of the house, we have no elucidation as to the standard that you're going to use. Literally, at the end of the round, all they say is individual justices say, I think this is cruel, I think this is unusual, I think there are some people who don't like it, even though that's factually incorrect. There's a lot of people who don't like this, even though that's factually incorrect. And we don't think that's a standard that you can rely on at the end of the day, insofar as it's going to change with the makeup of the court. Finally, under this point, they talk about the principles of equality and fairness that you should apply. I think we've sufficiently defended that these are written into the Constitution, so interpreting and applying the law as it stands is a standard that fulfills it the best. The third main argument that I want to close on is the bounds of judicial power. Because on both sides of the House, we've agreed that what the court's role is to interpret constitutional provisions. How do they interpret the language of the Constitution, particularly the cruel and unusual punishment provision? Well, what they do is they create standards with which they guide their decision-making process. The standard in this particular case is the evolving standard of decency. The framers are important, and in order to deviate from what the framers actually intended, the court must have something to check the capriciousness of decisions like they're advocating on their side of the house. Individual decisions of individual justices who have very, very different and sometimes categorical oppositions to things like the death penalty. It's very risky, Mr. Speaker, Madam Speaker, at the end of the round, to say they can divert from these standards and subvert the democratic process of legislation without any sort of justification in the Constitution. Finally, we would tell you that they are subverting democracy. In 38 states, it says you can kill minors for whatever reason. We've said there are legitimate justifications for states to do this. One of the justifications for killing minors is to deter them from committing heinous crimes like killing their teachers and throwing them off bridges, or the localities are better interested in crimes that affect their community and they tailor justice to these individuals better. Whatever these reasons the states give, we think it's very legitimate, we think they have these rights, and we don't think the court has a right to subvert the popular will like they defend in their side of the house. For all of these reasons, we're still very